Welcome back. As we have been following for some time, Florida voters in 2018 overwhelmingly passed Amendment 4, restoring voting rights to most felons who have completed serving their sentences. In 2019, the legislature tried to undermine that amendment by requiring those felons to also pay all court-ordered fees, fines, costs, and restitution before being able to cast ballots. Last Sunday, a federal judge ruled the Republican-backed law denied the poor the right to vote and was therefore unconstitutional. 2 weeks ago, we had Julie Ebenstein on this show. She was the lead attorney for the ACLU on the case. We checked back in with her this week after the ruling.
Governor DeSantis said this week that he would be appealing the decision, that the state would not accept the judge's ruling, that they would, move forward with an appeal. Your reaction to that?
It's we haven't received an appeal yet, but there was a preliminary injunction in October, and they appealed from that, and it was affirmed unanimously by a 3-judge panel of the 11th Circuit. If once we receive a notice of appeal, we'll respond accordingly. But if they appeal again, then we'll all take it up with the 11th Circuit again.
But I think the concern would be that if there's a series of appeals before the 11th Circuit, before the full panel, and then ultimately possibly to the United States Supreme Court, that what you end up with is a delaying tactic that could keep people from being able to register and vote in this year's election. Is that a concern?
Well, that may or may not be the objective, but as of now, a federal court has interpreted the Constitution to say that this group of people can vote, and they can register and vote right now. As it goes forward on appeal, there's no automatic stay of a district court's decision. So the operative decision is the one we just received this past Sunday. It's unconstitutional to prevent people from voting on the grounds of inability to pay and for amounts that are considered poll taxes. That's how the system will operate now. People can go out and register to vote right now. So, we expect if this does go up on appeal, that the appellate court will likely move it quickly. And we expect that only because that's what they did the last time around after the preliminary injunction. They gave us a very expedited briefing and hearing schedule. We still think that this will be resolved through the appellate process well in time for the 2020 general election. But in the meantime, the decision that we have interpreting the meaning of the Constitution is the decision in place and is the state of the world right now, so people can go out and register.
People sometimes forget you actually are representing real people. And when I say that, I mean you have actually named plaintiffs, people, individuals, not just a large class of people, but individuals who you represented in this case.
They're thrilled by the decision. It's one of the, we've all worked very hard on this case, and it's one of the most gratifying moments to get to call your clients after you get a good decision and tell them the result that they've all put time and energy and work and hope into for the past year. So we have clients like Betty Riddle, who lost her right to vote when she was convicted at the age of 17. She's now a great-grandmother. She has never been able to vote until we brought this lawsuit. We have another client, Mark Mitchell. He has also never been able to vote because of a conviction when he was a teenager. He was able to cast his first ballot in the primary, and he's looking forward to voting in November. We have 17 individuals who we know of, whose stories we presented to the court, who will now be able to register and vote. So that's really one of the most gratifying parts of litigating a case like this.
We'll be right back.